Good morning, everyone. Confirm if you can hear me.
Yes, I can hear you.
Okay, thank you. Class chef, are you in class? The class chef, are you in class? Or deputy class chef? Adjunct class chef.
So I didn't get you.
I asked class chef, are you in class?
Yes, sir, I am.
Okay. So you could see the number dwindling down. Before this is 930 now. Before you'll have had almost 300 in class. So what that simply means that you are tired of class. So I could have as well even cut to this class off so that you are going to read your book. So that's my own conclusion about the attendance that I'm seeing now on display. So, but not to prejudice others that have been staying active on the platform, I will just quickly go straight to our task today, which is to conclude maybe in 15 to 20 minutes the presentation on the distinctions between exclusion clause, disclaimer, and warning. So if Aliyah is in class, Aliyah, are you in class? Aliyah.
So I don't think she's in class.
Okay, but I can't hear her. I can't see her. Okay, Aliyah, if I'm not in class, then let me call another person because she was about to conclude that day, and I said, "This your time that we should." She will start today. Okay, so is who again? I think someone volunteered to present as well. Who are those people that volunteered to present the last day? Please let's do this quick so I can leave the class on time. Well, if no one is ready to present, so all I'm going to do is that please read your distinction between exclusion clause, um, disclaimer, and warning. So let's move on, please. Okay, Joy.
Hello, sir.
Okay, Joy. Can you turn on your cameras? Can you turn on your camera so that you go ahead? You have 3 or 4 minutes to make your presentation. So I can move to at the task for today.
Okay, sir. Sir, can you see me?
No, not at all.
Okay, my video is on though.
Well, class, can you see her? Yeah, I can't see
Yes,
her.
sir.
Yes,
Yes,
sir.
Yes.
If they could see you, go ahead.
Okay. So the assignment you gave us was to distinguish between disclaimer notice, exclusion notice, and warning notice. So, while I was doing my assignment, I made mention of the fact that there are different laws that govern occupiers' liability, and as provided by Section 2(1) of the Occupiers' Liability Act of 1957, an owner of a premises is required by law to ensure that his premises are safe, such that people who come to his premises, lawful visitors who come to his premises, will not be hurt or injured by by things that may be in his premises. So I then went further to say that, however, an occupier of a premises can escape liability either totally or partially if he can plead this, if he can bring up this defense of notices, because in our class told us that aside contributory negligence and volunteering on fit injury, these notices can also be used as a defense. Yes. So I spoke to disclaimer notice. So disclaimer notice is basically an occupier of a premises disclaiming, he's saying that he does not owe any obligation or any duty at all. He does not accept any liability at all for any person that comes to his premises. So if you are coming on your own. You are coming on your own. So yes, that's what this disclaimer is. He's saying that he doesn't accept any liability at all for people that comes to his premises. So any visitor that comes bears the risk, bears whatever risk he suffers from that premises. Okay. So by implication, it's like warning people of that if you're coming here, you're on your own. So also I made mention of a case that where the court stated that, I think that's the case of Ashdown and Samuel Williams also. Yes, where the court stated that if you are putting up a disclaimer notice, then it should be effective enough, it should be clear enough to disclaim that you are not taking any responsible, and the person should have also seen it, read it, and understood it. And I may mention the fact that this may not apply to children, because a child of 3 or 4 may not necessarily be able to understand what your notice is saying. So yes. So
Okay.
I went for that talk. Okay.
Go ahead. Okay, go ahead.
Okay. I went for that to talk about exclusion notice. So unlike disclaimer notice, where the occupier does not admit any liability at all, any responsibility, exclusion notice, he does admit that yes, I owe you a duty of care, but if you are coming on my land, you are not going to sue me. So you made mention of it in class that this can also be a case of voluntary non-fit injury, in the sense that you are the one that you are opting on your own to come. So if anything happens, you are going to take it like that. So in exclusion clause notice, in exclusion notice rather, he limits his liability. Basically, and the effect of this is that something you made mention of that I picked in class also was the fact that this does not necessarily mean that the court will not award damages against him if harm is done to a visitor on his premises. But what it means is that he will only nominal damages will be awarded against him. Why? Still the issue of voluntary, as per you knew, and you still enter. So only minimal damages will be awarded against him. So the effect of this is that if he can prove it, unlike disclaimer where he will be fully exculpated, in exclusion, he may still be partially liable for the damage that has been done, for the injury that has occurred to the visitor. And also warning notice. So this is basically you telling the public that stay off this premises. Let's say there's a dog, beware of the way they usually put beware of dogs or stuff like that. So you know that okay, it is warning you off from coming into the premises. Okay, so by warning people off your premises, you are taking reasonable steps to prevent them from coming. So anybody that comes to your premises is going to have himself to blame. However, the court has held that for warning notice to be able to fly as a defense in the court, then it must be reasonable. Okay, it must be reasonable, it must be well understandable by the person who is coming to your premises. And I also made mention of the fact that the court requires a higher duty of care as regards children. So the fact that you put a warning notice in your premises to warn of it, like it may be able to successfully warn of an adult, yes. And if the adult comes on his own accord, you will be able to escape liability. But for children, it may not necessarily apply because they are children. Okay. And I made mention of the case of Glasgow Corporation and Taylor. Yes, and in that case, what happened was that at the park there was a warning notice, yes, but the park had allurements in form of berries. So these berries are, the way children usually get curious and all of that. So the child went to the premises and ate the berries and died. So what was the court saying? The court was, I think it was Lord Genuine. It was saying that when you have such allurements in your land, you have to take much more reasonable steps to ensure that people like these children are not going to be hurt by your premises. Then lastly, I brought in the provision of the Unfair Contract Terms Act, provision, which says that I think that's section 2 Yes, section 2(1) A and B. Okay, so it says that where harm is done to somebody on your premises as a result of your negligence, and the person dies, or or suffers injury, and as a result of your own negligence, then you will not be able to escape liability, irrespective of any notice that you have put, irrespective of how big and bold you might have even been, as long as you are negligent. And this applies to business owners. Yes, let me not forget to mention that yes, it applies to business owners. So as long as the harm is done on your premises, and if a person dies or yes, is injured as a result of your negligence, you're not able to escape liability. And also, if it's not an injury to the person, but it's injury to property damage or any other kind of damage, you will only be able to escape liability if you can show if you can fulfill the requirements of reasonableness, the fact that you want to be reasonable and all of that. So
Okay,
yes.
yeah.
So in conclusion.
Okay, conclude. Good of time.
Okay.
Conclude.
Okay, so in conclusion, basically these notices, they work to help an occupier of a premises to escape liability, especially when he has done all he should have done, especially when he has done his due diligence, and people still saunter on his premises and they suffer injury. So it can help in escaping from liability. Thank you, sir.
Okay, thank you, Joy. Yes, before I make my comments, let me list one or two. Okay, Faith Adebayo.
Yes, sir. Can you hear me?
Yes, clearly.
Okay, sir.
Yes.
So, the three types of notices that we have, as she rightly mentioned, are the exclusion notice.
They can't see you. Can you see her?
I'm unable to turn on my camera now.
Because I don't want. You know why I always insist that you turn on your camera. When I take the volunteers, I have 7 persons that volunteer. So after those 7, I'm not taking anyone again. So okay, just do that. Just do that in 2 minutes because this I can't see you. I'm not inclined to take in the comments through AI. But go ahead.
Okay, sir. So a disclaimer notice is simply a type of notice where let me sure and turn on. Hey, can you see me, sir?
Okay, yes.
Okay, so a disclaimer notice is a type of notice that tries to absolve an occupier of liability. So, for example, if a person should place a sign on their door that says visitors enters at their own risk, or something like that, it's to try and absolve the occupier of a premises of any liability that may occur as a result of an injury suffered by a visitor, right? And the thing with disclaimer notices is that they are usually placed on a signage or somewhere that is very obvious for a visitor to see. And this is why in the case of Ashdown and Samuel Williams Limited, like Joy rightly mentioned, the court also stated that for a disclaimer notice has to be something that is very visible for the visitor to see and also understand, right? So it was also held in that case that merely notifying a visitor that you were not accepting responsibility or liability for their safety while entering your premises would be adequate enough to absolve you of the liability. So an exclusion notice has like dual roles in the sense that an exclusion notice can exclude certain or particular types of visitors from entering a premises and can also exclude the occupier of a premises from being liable for certain injuries, right? Exclusion notices are primarily used to restrict access to certain areas. For example, this is usually common in construction sites where they would tell you like, oh, danger here, electrical wires here, please do not enter. Or they will tell you stuff like, no unauthorized personnel is allowed in this place. This is simply to let you know that if you are not an authorized personnel, you have business in this place. So like any liability that occurs where a person enters that particular premise and is not authorized, the occupier will be absolved of liability. And warning notice, as the name implies, is a type of notice where someone is alerted about a potential risk or a potential danger in a particular premises, right? And if they choose to enter that particular premises with the notice that there is something that can cause them harm in that particular place, the occupier will not be responsible for that. And this was in the case of Copeland and Eagle Bros Limited. So what happened in that case was that the plaintiff was electrocuted by a live electric wire that the electric personnel failed to turn off, right? And the court held the occupier liable. Why? Because the occupier knew that there was something dangerous in that premise, but didn't put like a warning notice. For instance, if you go to some houses, right, you see like a sign or something telling you like, warning, there's an electrical wire here, right? But that was not what happened in this case. The occupier did not inform the people in that case, the visitors, that there was an electrical wire there. So when someone died as a result of being electrocuted by the live wire, the court held the occupier responsible. So one interesting thing about these three types of notices is that they are very similar, but they have like very little differences, right? Disclaimer notice simply limits liability, but doesn't like necessarily absolve an occupier of a liability. Also, exclusion notice like restricts access to certain people or to certain places of a premises, right? And as Joy rightly mentioned, we also have the Unfair Contract Terms Act, which also regulates contracts by limiting the extent that an occupier can absolve himself of liability by using exclusion clauses like disclaimers. So like one salient thing I noticed among these three types of notices is that although they can serve as a defense, they do not necessarily exclude an occupier of complete liability. Like if the court looks at the facts of the case, to an extent, an occupier might still have liability to the visitor, but maybe it would not be as intense as it would have been if there was no notice at all. Thank you.
Thank you, Faith. Thank you, Faith. Well, I don't want to be tempted to dabble into the arena, but let me see if one or two person can also corroborate or complement what others have said. So let me call on who again? But I've taken when I was shouting who want to kickstart the discussion, nobody volunteered until Joy. So I wrote the names of those that raised their hands up initially. I called Aliyah several times, he didn't answer me. So I think I would like to call on a piece now. A piece of Okoli. A piece, where are you?
I'm here, sir. Good morning, sir.
The piece, you be doing yourself the service. Your name is not carrying your matric number, and that's dangerous.
Hey,
okay. But I don't go ahead. But because I can't score you without matric number. Go ahead anyway. So
okay, I'm trying to correct it now. Okay, sir.
Sorry, excuse me, sir.
Okoli, go ahead, please.
Okay, sir.
So like Joy, I'll pass your stage. Your classmate will tell you I was calling your name several times because I promised that you conclude. I won't resume today. I was calling your name several times. You didn't answer me, so I almost even closed this chapter before Joy savage your class. So go ahead, Okoli.
Thank you, sir. So like normal, like when we go around this our environment and our day-to-day activities, we usually come across disclaimers, warning notice, and even exclusion clauses, especially when we are trying to board flights and that. And they are basically just telling us that, okay, you are using this stuff at your own risk. Your car that is parked here is at your own risk. And while they may seem as nothing, they are actually, their main role, as we've noted, is to make sure that the occupier or the owner of that premises is not liable for any damages that might occur when people are on that land. So warning notice is just as the name implies, it simply means that if a visitor is harmed by that, if a visitor comes into an environment and is harmed by a dangerous feature on that premises that is owned by someone else, the owner can argue that, okay, prior to when this person entered into this premises, he has seen a notice, a warning notice on this place, like beware of dogs. So if he enters into that premises disregarding the notice that he had put on the outside and just enters into the premises, not being conscious of the fact that, okay, yeah, there was a warning notice outside, then the owner can decide to say that he's not liable for any damages that might occur to that visitor that has entered the premises, regardless of the fact that it saw beware of dogs outside the premises. And this is in line with the Occupiers Liability Act, that is the OLA of 1957. And if the warning, and the court has made us understand that if the warning is sufficient for the visitor to be reasonably safe, the owner has discharged their duty. That is the duty of notifying the visitor that the area is not, that is the premises is not entirely safe for his visit. Now, Section 15 of the Other Act of 1984, it has also is kind of different from that of 1957 in the sense that it kind of discharges that after taking reasonable steps to warn the danger or the one of the danger or the individuals that are coming into the after taking steps to warn individuals or visitors that are coming into this place, the duty owed regarding a risk can in sometimes or in appropriate cases be discharged or not discharged. Therefore, what that particular section is telling us is that even if the claimant received a warning notice, the occupier, even if he can also argue that he has fulfilled his duty of care under 1957 and 1984, sometimes unfair contract terms would not allow him to go free, would find a way to make him liable irrespective of the warning notice that he has done. So it simply says that even if you have given warning notice, for example, to be beware of dogs, for somebody that's outside, your dog should probably have a leash on when it is during the daytime, and maybe at night time you can let the dog be free, because it is generally assumed that most crimes occur at night, right? So that's for one notice. Therefore, disclaimer notices, what I was able to notice that it simply suggests that the occupier, as name implies, can disclaim the common duty of care. It can simply say that although it would normally owe a visitor a duty of care in compliance with 1957 OLA Act, but nonetheless is saying that it can disclaim that care. However, for him to effectively disclaim this duty of care, there are 3 conditions that must be met for that disclaimer notices. First, the visitor must have seen the notice. Secondly, the visitor must understand the notice. And thirdly, the visitor must be on the land with the occupier's permission and not by rights. Right? Yeah. So that is the 3 important things, conditions that must be met for a disclaimer notice to be effective. And if any of these conditions are not met, if any of these conditions,
I thank you. That is peace.
Yes, sir.
Yeah, peace. I think I will stop at that so that others can also make contribution. Class, you see what peace said. 3 conditions that must be met before you can be discharged from duty of care. Those 3 conditions are very important for disclaimer purpose. So, and she has also mentioned the situation under the 1957 Act. So, just like Faith also mentioned, there are slight similarities, so difference between these 3 concepts. So, anyone that wants to answer questions in this area must ensure that you know the position under the 1957 Act, you know the position of this concept under the implication of this concept under the 1957 Act, under the 1984 Act, then even under the Tort Law Reform Act of 2013, law of 2013, Lagos State Law of 2013. So, then what also the position under the common law? So please note all these important distinctions between these 3 similar concepts. Okay, so let me take on on my record Olatunji for 2 minutes as well. Olatunji.
Good morning, sir.
Good morning. I'm going to stop class presentation by 10:15. All right, go ahead. You have 2 minutes.
Okay, sir. So the assignment asks us to make a distinction among the 3 concepts. So for me, I believe a convenient way to start would be from the provisions of Section 2.1 of the.
They can't see you again, no.
Can you still hear me, sir?
No, they can't see you. I can't see you, and I'm sure they can't see you. Okay. Now,
Can anyone see me now?
you're live. You're live now.
Okay, so I said that for me, I believe a convenient way to start would be with the provisions of Section 2(1) of the Occupiers Liability Act of 1957, which states that an occupier owes a common duty of care to ensure that his premises is safe for those that are coming in for any other duty as it may be. But then it is worthy to notice that that same section states that an occupier can limit or restrict or even modify his duty of care by a notice or contract to the contrary. So the pressing issue would then be whether with such provision as to restriction, modification, or exclusion, an occupier can totally absolve himself from liability. And whether this can be or not, we have to make reference to the three types of notices we have. And the first one I have here is the disclaimer notice. So disclaimer notice is basically what I call notice of denial. It's basically an instance where an occupier is saying that he denies any legal responsibility to watch out for the safety of any person on his land. That is, he's not even trying to say that he accepts, then later debunks. He's stating from the inception that he has no duty of care to look out for the safety of people. So when they are coming onto his land or his premises, they are to ensure their own safety. So basically, when you see a notice like no responsibility accepted for the safety of people or their property on these premises, that is a good example of a disclaimer notice, because it's entirely, I don't use the word disclaimer, it entirely denies or exculpates an occupier from any legal responsibility that must have accrued to him while under the Occupiers Liability Act of 1957. So that's what that is. So it's basically a notice of denial. But for the other one, exclusion notice, this one is basically saying that, okay, we accept our duty under law to watch out for your safety, but you have to agree while coming onto our premises that you do not take any legal action against us in case you get injured, or even if you have to take an action against us, it will be for a limited amount of damages. So this one is basically the owner or an occupier trying to watch out for himself by saying that, okay, I accept the liability that I have to watch out for your safety. But in an instance where I failed in this duty and you probably get injured, you either have to agree that you will not sue me. And even if you sue me, the amount of damages you would ask for is limited. So that's basically what exclusion clause is saying. So basically, there's a presumption under exclusion notice, rather, that we failed in our duty. They are presuming it that we failed, but even though we presume our failure, you still cannot go on with a free hand to take up a legal action against us without a limitation on your right to action and your right to seek extensive damages. So that's basically what it's saying. So an instance where you see a notice that states that no liability accepted to anyone suffering harm on this premises, that is a good example of an exclusion clause. An exclusion notice, because it's saying that yes, we accept that we have to look out for your safety, but in an instance where you do not probably get your safety guaranteed, you have to note that you've agreed not to take a legal action. And even when you do, your damages is limited to what you agreed to do. Now, the one that I found rather common is the warning notice, and this one is basically warning about a potential danger. That one is very common in society or the community, where you have someone saying that watch out, shaky handrails, or beware of danger, or all those other notices we see, particularly around those transformer areas and any other thing that can cause danger. So it's basically saying that as you are coming in, take note of this danger. And then I would love to make reference to the provisions of Section 1(5) of the 1984 Occupiers Liability Act, which state that the duty, with a warning notice, a duty of an occupier might be discharged towards ensuring the safety of its visitors. However, it is important to notice that the court is not always inclined towards holding an occupier exclusively exculpated from any liability, because you would see that Section 2(4) of 1957, 2(4)A of 1957 Act, that is the Occupiers Liability Act of 1957, it says that we should not just on the surface of it or prima facie take it that someone with a warning notice on his premises has absolved himself, but we must be able to ensure that such warning notice has will keep such a visitor or trespasser in sorry, not a trespasser, a visitor rather, in to be reasonably safe. So in here, how I can describe this is basically stating that what about an instance where a person takes a notice and places it rather at a position where it will not be easier to see or to read, like where you have a warning notice as to a shaky handrail. The notice is even placed after the person would have even climbed the staircase. So how does that become an effective warning notice? So in such an instance, the court is saying that warning notice is not effective because it is not brought to the attention of the visitor in that instance. And even where it is not reasonable, it is not one that brings into a reasonably safe instance, such as to absolve an owner of liability in the instance. But then I would love to note that one thing I find interesting in the case of Statement, West Dorset District Council, where the court held that where a risk is so apparent, it's so obvious, then a warning notice is not required to absolve liability. So that case was where a man crouched on a wall, very slippery. Apparently, once it gets wet, it's very slippery, and even while touching, you know, observe that it's very slippery. But this man, to take a picture, an aerial view of a community, he had to climb that particular wall. But whilst taking the picture, he slipped and he fell. And the court held that there is no need for he brought a claim that the man didn't put a notice as to the slippery nature of the wall. But the court said that even while climbing, you would have noticed that this particular wall is dangerous.
Oh, Olatunji, we have lost your audio. Okay, I think let's leave Olatunji as that. Yeah, he has tried. So let me call on Tovishade. Tovishade, am I right?
Good morning, sir.
Oh, okay, good morning. Good morning.
Good
Class,
morning, sir.
class, do you follow analysis of Olatunji? In fact, if Olatunji is presented with a question of this nature in the exam and he is able to analyze the way he did, honestly, that would be moving to a superb grade. So I want to know that. Okay, Tovishade.
Yeah, thank you, sir. Good morning. I've listened to everything that other speakers have said, and I just want to make a comment on the exclusion notice.
Okay.
So for the exclusion notice, one thing that we must know that on that.
Yes, sir. Go ahead.
Oh, Olatunji, don't worry.
Contract Act.
Don't worry.
Yeah. So there is a distinction between premises that are used for business purposes, as Joy has mentioned. But one thing that we must take note of is that where a particular business is actually into the admission of people, then such a business may not really rely on an exclusion notice to actually exclude them of of liability. And such premises could include, for instance, an amusement park. It could include, for instance, a railway station. It could include, for instance, generally places that kind of admit people. You understand? Those kind of places may not be able to rely on an exclusion notice to actually exclude them of liability. And Winfield and Lewis actually laid a distinction by giving us an example of a farmer who has a farm, and then anybody that comes into that farm, if the farmer has already placed an exclusion notice, then that exclusion notice may avail him, because that place naturally, or that premises naturally does not admit people. But if it's a place that naturally admits people, then the farmer may not be, sorry, if it's a place that admits people, in this case, it's not a farm, maybe like a railway station or other places. So in that kind of instance now, an exclusion notice will not be able to absolve the defendant of liability. And that's why Winfield and Lewis actually noted that the decision in Ashdown's case would have been in the reverse, because naturally it was a railway station that actually, that naturally admits people. So it was like the decision in Ashdown would have been the other way. And one thing I must notice is that Ashdown came just some years after the 1957 Act has been enacted, and also prior to the Unfair Contract Act of 1977. So the decision in Ashdown wouldn't have been wouldn't have been to absolve the defendant of liability if and only if the Act of 1957 had been enacted before that case came up. And also, if we should check the case of White and Blackmore, Lord Denning actually said something in that case, because in White and Blackmore, what happened was that there was a jalopy, like a kind of carries in which people were admitted to participate in the carries and everything. So the claimant in this case actually came for the carries, was a participant. And also, one thing I must understand about exclusion clause is that, as noted by Winfield and Angelo, he said that under the common law, of course, there are four categories of people. We have the contractual entrant. Now, what I must notice about the exclusion notice is that it kind of ameliorates or is kind of amenable to the contractual entrance. People that prior to their entry into the premises, there has been like a contractual undertaking. For instance, whether wants to enter into a railway. In this case, it might not really necessarily be a trespasser, but we know that what's it called? Premises that naturally admit people, there's a kind of implied contract between the entrant and the occupier. So in this case now, we also know that exclusion notices most time, appeals or is amenable to contractual situations. So and that's why, sorry, let me revert to White and Blackmore. So in White and Blackmore, Lord Denning actually noted that the exclusion notice in that case was not such that could be relied upon by the defender. Hallelujah, sorry, can you still hear me?
Go ahead.
Okay, so Lord Denning actually noticed in that case that the exclusion notice would not absolve the defendant in that case, because number one, the premises was such as to admit people naturally because of the events that, and also an exclusion clause in that instance was not sufficient enough to actually exonerate the defendant, because the defendant cannot be said to have taken all the care that he ought to have taken, and then at the same time exclude himself of liability. Because if you are actually excluding yourself of liability, I have not taken all the necessary steps to ensure the safety of the entrant in that case, being that your premises naturally is one that admits people, then you cannot rely on an exclusion clause to actually exonerate yourself. So that's what I want to add.
Yeah,
thank you, sir.
That intervention is timely, and you heard what the minister said about when you read up some cases. I've had cause to receive your classmates coming to my office. Though you are on digital learning platform, but I see some of your classmates coming to my office once in a while to ask questions about they read this kid, they read that kid, they read the other kid, and the fact that they're conflicting. This is what this one said. This was, and the question I always ask them is that, did you check the dates? Did you check the dates? Those cases were reported. So it's very important, and that's exactly what the minister has done. That the accident case, if that case was to be determined with under the operation of the 1984 Act, perhaps the court will have reached a different opinion. So please note, when you read the cases, in as much that I will not penalize you for not putting the years when you report cases in the exam, because that's not my way. So and I don't say any that will penalize you for not putting the year when you are setting cases in the exam. In as much that will not be expected to put in the case was reported, the parts, the page, and all that. But on your own, when you are reading, ensure that you're able to distinguish between these cases, so that you will not be taking the principle of 1957 to mean the principle of 1984, and the principle of 1984 to mean the principle of 2013. So I'm happy that Ebenezer had done justice to that area. Now, before I go, let's call on the Omali. I'm calling the names on the other priority as indicated on my screen before some volunteers started cropping up. So Omali, hallelujah. You have the floor for 2 minutes, please. Let's be fast. I can commence the task for today, which is tips on how to answer a lot of questions.
Good morning, sir.
You have the floor.
Can you see me?
Yeah, clearly.
Okay, thanks, sir.
But
Okay.
your audio is not loud enough. I don't know what happened to your audio.
Okay. So the question says we should distinguish between disclaimer notice, exclusion notice, and warning notice. So, in occupier's liability, property owners or those in control.
Only, so no, is there you want to add to what Faith, Joy, Ebenezer, and others have said that we have not heard from them? So,
okay, let me just point out some important things to take note of in those 3 notices. So for disclaimer notice, it's like a legal statement that clearly states that the occupier does not owe any duty of care to anybody for damage or harm that is caused to such a person on his own land. So disclaimer notice is simply not accepting the duty of care, and is telling anybody or any entrant to the land that the occupier would not be liable for any damage that is done. So, but the thing that we should is that if in case of gross negligence, the disclaimer notice might not absolve the occupier from liability. So it is very important. Even though it is very clear and it states expressly that he is not accepting liability, the court will not hold, the court may still hold the occupier liable if they see that he was grossly negligent in that regard. So one of the things that was mentioned by one of my colleagues was that the disclaimer notice must be very clear in a very obvious place, and it must be understandable. So in the case of
wow. Who is affecting them? Who is affecting Hallelujah now?
Sir, can you hear me?
Okay, go ahead now. Go ahead. You are back. You are back.
Wow. Okay, so I said that in the case of Anson versus Liberty Group, so one of my colleagues mentioned the other time that the disclaimer notice must be very clear in an obvious place and it must be understandable. So the court held in this case that the disclaimer notice, which was not clear to passerbys, that is, anybody was to enter, but only clear to people that come in through vehicle, could not be described to have absolved the occupier of liability to those who enter by foot, because it was only clear to people who come in through the vehicle. So the court emphasized it in that regard, that the disclaimer notice must be very clear and in a very obvious place to everybody for the purpose of absolving the occupier's liability. So for exclusion notice,
I think it's Omali audio is bad. So Omali, let's yield floor to for last person, which is Valentine. Valentine Ubezu.
Okay, I'll turn my camera on.
Yeah. So please tell us what you have not heard from these erudite scholars that have spoken earlier on. So, or maybe you want to clarify or you want to add before we move on.
Well, they've said a lot, and I don't think I might really add anything new, but I might just say 1 or 2 things based on what I did in my assignment. That's all.
Go ahead.
Well, I don't know whether.
Go ahead. Please. Go ahead. I'm snapping.
Yeah. Okay. Yeah. Okay. So in the realm of past liability, the concept of disclaimer notice, exclusion notice, and warning notice determine the extent to which an occupier can limit their liability for
Bello Idamala. Bello, you are disturbing our class. Bello Idamala. Class friend, can you help me? Let me give Bello Idamala minor school. My number is 210601046. Let me give Bello Idamala minus 2, please. Go ahead.
Okay. So, in other words, these terms, in the context of occupiers and liabilities, is sign or a statement displaced on properties, and it explicitly informs visitors that the occupier is not liable for any injuries or damages sustained on the premises, effectively limiting their legal responsibility to a certain degree. Doesn't fully limit their liability, usually due to inherent risk of specific conditions present on the property. So we would have to have recourse with the first act, or we have to look at the Occupiers Liability Act of 1957, and Section 2 of that Act says that the common duty of care the common duty of care is a duty to take care as such in all circumstances of the case. It's reasonable to see that the visitors will be reasonably safe in using the premises for the purposes for which he is invited or permitted by the occupier to be there. And Section 3 sub 1 says that an occupier of premises owes a duty of care towards a visitor there to accept insofar as
Valentine, you know, we're not yet of February 14. Summarize your points so that we can move. You know, this 10:15. I said I will not take any comment after 10:15, but this is already 10:16. Just summarize in like a minute.
Okay, so
yes.
So yeah, they give an exception to children in Section 3. They give an exception to children. I think that's in Section 3 of, also in Section 3 of. So then if you can find these laws that are relating to occupiers liability in terms of this, what they call it, these notices in the TORTS reform laws, Lagos, in law reform TORTS law of Lagos. You see them in Section 7 sub 2, Section 8, and so on and so forth. So I wouldn't waste much time there. Then disclaimer notices.
Those sections you are citing, I hope they are not old sections. Because I could see that most of you, you know, I was reading through your work, not all. I just feel, and I saw that people were citing, they were citing the coding and local sections. Those Section 2, Section 8 of coding and local, those are not sections of tort law reform law of Lagos State anymore. So, and that's why I warned you that I'm not, coding and local is good for basic study. But if you want to rely on it for exam, I wish you the very best. For me, do your research, compare notes. So, Aluko and Koli can never be the authority for, especially for occupiers liability, which was discussed just segmentally in that textbook, maybe like 2 pages or not. I've heard people saying that, sir, that I saw where you did your research for, and I said, if you think I use coding and local, then you're your home. Because you come to my office, you see I have like 7 textbooks on law of torts. 7 textbooks on law of torts. So what I do is to consult these authorities and make my points from those authorities. So please be careful. I'm not saying you are wrong, but if you are citing Section 7, Section 8, those are the sections under the old law. So I want some of that just to clarify that point. So I think we've had Valentine. So that's also a good contribution. Because of time, I'm not able to take others, but these are people that indicated interest from beginning to contribute. So
Excuse me, sir. Please, I have a question, sir.
Okay. Okay, before you do have time.
Sir. So when we are talking about exceptions to these notices, we talk about the fact that children might, an occupier might not be able to rely on these notices as a defense where the parties are children. Now, I'm wondering, is there any provision for other people or other vulnerable people, like people with disabilities, like people that, to put it mildly, are idiots, they have maybe their brains are not developed properly, so they can't understand certain of these things. Are there provisions for them to fall on that?
I'm sorry for cutting you. So that is why I gave the assignment out. I gave the assignment out specifically for you to do research and let us look at those things in class and see whether there could be remedies for those that are also physically challenged, aside from the from vulnerable children. So there, of course, there are others. And if you listen to the comments of your classmates this morning, you will see that they're able to distinguish from instances where disclaimer may likely exculpate, also warning and all that. There are, but that's why I asked you to read ahead, read very well, read through cases that have been decided over the year. I've given many cases on compatibility. I deliberately take time to take discussion on these points, so that if you see it as maybe a sub question in the exam, then that should be a bonus for you. So yes, read further on these points, you'll find answer to them. Because of time, I don't want to use my time on maybe 2% discussion of compatibility, because this is actually like 2 or 3% discussion. I just brought this out under defenses that aside from contributing negligence, aside from volunteering of the jury, you may also need to look at exclusion clause, look at a disclaimer, look at warning, and see whether the occupier can be exculpated from liability, or whether these concepts will not avail him when he's making his defense before the court. So I think we are settled on this one. I don't want us to drag it beyond that. Now, for Bolaji Boluwatife, is there a question? Do you want to ask a question, or what do you want to do? Because I can't take comment anymore. I gave you enough time before I wrote the names of those that I called earlier. The only person that also volunteered very late was Samuel, Samuel, and Christopher Benjamin. I'm not able to take them for now because of time. So on that note, I think let's leave the debate on this point at that, and also to advise that know the implications of exclusion clause, disclaimer, and warning under the relevant law. What is the implication of that under the 1957 Act, under common law, under the 1957 Act? What is the implication of that under 1984 Act of UK? And what is the implication of that even under the tort law reforms law of Lagos State? So know these implications, so that when you see any question on this, you'll be able to address them. But my judgment about the class so far is that if all the comments you have made here were actually comments that came from your personal research, I am more than happy to say that you have done wonderfully well. From Joy, from Peace, to Olatunji, to Faith, to Valentine, to Ebenezer, to Omole, who's all the letter failed. Then I think with that, I'm rest assured that your comment will translate to a better performance in the exam. So that's what I want to say as regards that. So I'm going to display something that we're not able to finish today. And I told you that I'm ending my class today, but that if your class rep get back to me on your convenience, then I will continue the discussion of what I want to start today, which has to do with tips on how to answer law question, and also treat maybe one past question with you, especially on the area that I've taught you, so that when you are always sure that you are 99% set for the exam. And I'm glad for my for the feedback I got from your classmates. Professor Adekele had come to class to take you through the ways to answer law questions, and she also told me that she took some past questions with you. And so with that, you are very blessed, and I want to believe that you will not disappoint us in the exam. And please just relax. There's no big deal about TOTS. TOTS should not be dreadful to you. It should be something that you should love writing the exam on every time. And that is true because they are based on principles. They are based on principles. And it will help you to also understand other courses that you are taking, criminal law, commercial law, and all that. So let me see if my screen can be displayed. A class will confirm if you have this notes are being shared on the screen. I gave this notes to the first time I prepared this notes was I think 2013, when I was a teaching assistant at the commercial law department. I gave it to a particular class then. Who are people still raising their hands? Please lower your hands now. Are we not done with that? Is there anything you want to say again? Hello, these people that are
Yes, sir. Please.
what again? What? See, we are wasting time. This is almost at 10:30.
Sorry, I don't have a question, sir. I just have a request, sir, about the slides for the occupiers' liability, sir. We have not gotten them.
I told you to follow up your class rep now. So if your class rep does not follow up on me, that's not my fault now. I can't speak with you to the extent that I will not be begging you to remind me to give you the slide. I've told your class rep in this class that before 18th of this month, ensure that you follow up on me. That I have a couple of work I'm doing, and I also want to set questions that I want to have time to go through it for now. But that over the weekend, maybe over the weekend between now and Tuesday next week, you should let me. You should try and remind me so I can work on it and send to you. But if you just remind me, then whatever you have learned in class should be enough.
Okay, sir. Thank you, sir.
Okay.
Excuse me, sir.
Sir, give us the one you have already, so that when you finish that one, you can send letter.
That's not the way it's done. So I'll give my rough. I'll give my rough drafts.
The one you used to teach now.
Class rep, can you see my screen? Class, can you see my screen? That request is not a good request. Class rep, can you see my screen?
We can see your screen, sir.
Yes, sir.
Okay. Yeah. So now, if you look at what I displayed on the screen, this is what I tag tip on how to answer law questions, and I look for the soft copy that I prepared that time. I couldn't find it because I rework it, but I can't find it. So I have to search my library to find this one. I think I gave last set as well. This particular one. So if you resume physically before the exam, I can also give it. I can give it your class rep so that you can copy from it. But you can just screenshot for now, or just follow my discussion on it. So now I start by saying that answering law questions, of course, had for a long time been a major problem to law students. Not only law students, non-law students alike. And so you find that that most students believe that law is a difficult course. And so that course is not a COURS. Like I said, I've reworked the point. So normal course. So end leading to mass failure. On the contrary, law is one of the simplest courses that any serious student should be able to pass well. And so you agree with me based on what I've been doing so far. I've interacted with some of your classmates, and I'm glad some of them will say they're 4.8, 4.7, 4.9. And so if that is the case, it means that law is not as difficult as some people thought. So now, what a student offering any law course should bear in mind from the beginning is that you must pay attention to the general principles, exceptions, if any, then the law that establishes that principle, sections where same can be found, and also decided cases which otherwise known as the case law. So, in other words, when students are reading, you must pay attention to the general principles of law, which we have been dissecting this morning. Aliyah, your hand is still up. Is there anything again?
Yes, I wanted to explain why I did not answer because I was not on the call.
Leave that one for now. Okay? Leave that one for now.
Okay, can you like make a small contribution on exclusion notice, something that I discovered in my research that was not mentioned during the discourse?
Aliyah, for now, we can't drag that anymore. See, I've given 1 hour to take a stress clause, and you're the first person I called. Your counsel can be a witness, and I also have it recorded. I called your name several times. It was when when you were not answering, and I had to ask volunteers, and nobody also volunteered. So I was about to move to this segment before Joy now raised up her hand, and it was because of Joy that made others to comment. So
I'm so sorry, sir, because I wasn't on the call. I was trying to charge my phone, and somebody had to call me.
It's all right. Don't disturb the flow of this segment, please. Don't worry. It's all right. So now, as advised, a reasonable and serious student should, from inception of academic activities, not to stay a day longer than necessary for the program of the study. In other words, if law course is 5 years, then we expect that within the 5 years, you're able to finish your program if you are dedicated. So, and you must be able to do the right thing at the right time. And do the right thing at the right time is pay attention to your lectures, do your task with fidelity, and ensure that when you are given tasks, submit the task within the deadline, not those that will submit after a day or 2 days, because these are part of things that can also affect your grade. When you submit your assignment or your task a few minutes after deadline, those submissions may not count for you. So you will not be there when lecturers are grading. So ensure that you do the right thing at the right time. So, and I said at least an hour reading per day may be the kicker. Now, that 1 hour per day talks about quality hours of reading, not that you just carry book and after an hour you say you are done. So there's no joy in reading for 10 hours in a day without paying attention. So if you have only 1 hour in the day, and you can start from now on, just only an hour in the day can be how do you call it, the joker for you, because when you read very well and you understand what to read within an hour, it could just only 1 page. You master that page, and all the principles you have been able to extract from that particular page. You set questions for yourself and you answer those questions. Then you move on. That is quality reading. Not when you have 10 hours and you be at the library, you talk with your classmates. That's not quality reading at all. And I said a student must also have confidence in himself before he can achieve anything at all. So law has to also do with confidence. When you have low esteem, you may not be able to do well in law. So you must be inspired by boldness. Be bold, be confident in yourself. Don't see yourself as a failure or dullard. If you read it and you don't understand, you can meet some of your classmates that you think I beat better than you. Don't shy away from that. Meet with them and ask for help. That's why I said a student must have confidence in himself before he can achieve anything, so that at the end of the day, you also join others to sing the song, I came, I saw, I conquer. So this preliminary is very important for any law student that want to do well. So now, having said that, I move on to say it on how to answer the question. Now, you know that there are two, of course, there are two types of questions in law. You have the problem questions and you have the essay one. Okay, so the SO1 is what I call short literary composition that one is required to write. Okay, and please don't misquote me. I said short literary composition that one is required to write. So by the word short, that does not mean they just write only one paragraph and say because lecturer said just short. So where in a question you are asked to discuss XYZ, for example, write short note on XYZ, disagree between XYZ. In these instances, you are expected to write down all that you know on the subject matter of the question. I'll come back to that later. That you need to write down all that you know on the subject matter of the question. So it's not that if they ask you discuss duty of care. After duty of care, you now move to breach of duty, move to damage. Then you now talk about the entire negligence. That's not what I mean by write down all that you know on the subject matter of discussion. Now, so what that simply mean is that the candidate must be able to adapt the material that you have learned on the subject to take into account the particular emphasis given to it by the question. So you only do well if you adapt the material that you have learned. Okay, so now you get very few marks for simply writing all you know about the topic with no attempt to address the issues raised in the question. So, and you have examples of what you call polling questions, or no, so essay question. If the question says examine, you're giving a statement like every restraint of the liberty of a free man is an imprisonment, although it be not within the walls of any common prison. Cook CJ, I mastered this point long time ago. So if you are presented with that particular question that so person says every restraint of the liberty of a free man is an imprisonment, although it be not within the four walls of any common prison. Examine the above statement with the aid of judicial authorities. This doesn't mean that you should write everything you know about false imprisonment at all. But you must put bear in mind that this question tilts towards false imprisonment, and that whatever that you know about false imprisonment, you must be able to adapt it on subject to take into account the particular emphasis given to it by the question. So attempts to address the issues raised in the question. And so also you said discuss the various defenses to trespass to persons, citing relevant authority as may be appropriate. You have been asked to discuss defenses. So don't now start by saying false imprisonment is this and that. Just go straight to defenses and give a brief introduction. Okay, that you know why defenses were designed. So give us the brief background on why you think defenses were designed. To do what? Then you now give us the various defenses that you have to trespass to persons, and you use authorities to back them up. You can get your full mark in that regard. So, and I've already said that short note in law does not mean that you are to write a very short note. You are expected to write all that you know about the subject matter. The lawyer is said to be one who will write 100 pages argument and call it a brief. But here, you are not expected to write 100 pages, but just demonstrate that you understand what the question is asking you. Now, under E as well, even if you have memorized an essay which does raise the issues in the question, perhaps because those issues tend to be raised every year. I've seen some past questions that I always advise those that are very close to me that pick like 5 years past questions on your own. When you finish reading, treat those past questions. You will see semblance in some of the questions that have been asked in the past. So, and that's why I said perhaps because those issues tend to be raised year after year. So when you see those questions, be careful when the question is reproduced in the exam, so that you will not cram and pour it out in the exam. So you be able to read those questions again and see whether the question that you have currently, though appear similar with one that you have that on your own that you have maybe solved in the past. Look at whether those questions are on all four with the one that you have presently. If there's a slight difference, then be careful. Read very well. You will know how to answer them. As I said, you must fit your material to the words of the question you are actually being asked. For example, this is what I'm talking about. Suppose during your course, you wrote an essay on the advantages and disadvantages of limiting compensation for nervous shock. You have done negligence. So a question has been asked as a question to discuss the advantages and disadvantages of limiting compensation for nervous shock. And then in the exam, you find yourself faced with the question, should compensation for nervous shock be subject to the same rules as for physical damage? Class, how are you following me? Because someone is raising up his hand. How are you following my explanation on this essay question?
Yes, sir.
Yes, sir. Yes, sir.
Okay, Rebecca, is there any issue?
Not really, sir. I just wanted to like confirm that there was one thing you mentioned about forced imprisonment. I always thought that meant that we should explain all we know about forced imprisonment, but you said that is not it. So I wanted to ask that what does the question now mean? That what is the question asking from us? Do you understand me, sir?
Yes, I understand. Now, did you read or do you hear what I said about the dictum of Koksiji? Says every restraint of the liberty of a free man is an imprisonment, although it be not within the walls of any common prison. So
yes, sir, I heard what you said about.
Thank you. So if now go and find out that particular statement where it came out from, then that will limit your scope of, or that will give you the scope of what extent you need to write of forced imprisonment. Not that you are going to be writing forced imprisonment as if you are presenting a topic and a lecture in class. That's what I mean. And also, you should not master everything about forced imprisonment and put it down. But again, the way you answer your question will determine whether you are lecturing an examiner or you are simply answering the question and linking it with the statement of Koksiji. That's the point I'm making. And that's why I'm giving you this particular example again. I'm giving you the example of nervous shock, which is negligence. And because if I have my way to ask question on negligence, there's no way I will not put nervous shock as one of my questions. Because that's another area that I find so interesting under negligence. So I said, for example, suppose that during your course you wrote an essay on the advantages and disadvantages of limiting compensation for nervous shock. That was what you have read in the past question. And then in the exam, you find yourself faced with the question like, should compensation for nervous shock be subject to the same rules as for physical damage? Now, you see that the first one, the question says, discuss or critically analyze the advantages and disadvantages of nervous shock. So of limiting compensation for nervous shock. That's a very straightforward question. Now you now see it in the exam, something similar by saying, should compensation for nervous shock be subject to the same rules as for physical damage? So someone who had crammed his way and want to impress the examiner will simply cram those answers that your seniors who normally sell handouts and all that, the answer they've given you that you have crammed will simply pour it down. So now the material in your coursework essay is ideally suited for the exam question. But if after briefly explaining what the rules on compensation for physical damage and for nervous shock are, you begin the main part of your answer with the word, the advantage of limiting compensation for nervous shock include, what I simply would tell the examiner is that this is a dead giveaway to the examiner that you are merely writing down an essay that you have memorized. That the advantages of nervous shock or limiting compensation for nervous shock include, what I simply tell the examiner is that you have crammed your way, because the question we are being asked is not the same as the previous one that you have crammed, which says discuss the advantages and disadvantages of limiting nervous shock, the compensation for nervous shock. They are two different entirely, but they are similar. So it depends on how you can craft your question, your answer, to suit the question that you are being asked, different from the past question that you have solved and you have crammed. Now, this is the best way to answer a question of this nature. So, and I say that it takes very little effort to change the words like this. There are a number of good reasons why compensation for nervous shock should not be subject to the same rules as physical damage. I repeat, I said there are a number of good reasons why compensation for nervous shock should not be subject to the same rules as physical damage. That is your introduction. It's not the same as the advantages and disadvantages of limited compensation for nervous shock include. It's different from my own introduction, which says there are a number of good reasons why compensation for nervous shock should not be subject to the same rules as physical damage. So, but it will create a much better impression, especially if you finish with a conclusion which, based on points you have made, state that special rules are a good or bad idea. So the choice depends on the argument you have made during your answer. So a good way to answer this question will show to the examiner is that, oh, this person did not just cram for me, but is trying to answer the question the way the questions are couched. You still list all those advantages and disadvantages, but you not just start by saying that the advantages are or include. So when you give us a good introduction, maybe like one line or two line, before now stating that, oh, the advantages and disadvantages for this are, the examiner will know that this person is ingenious. The person is not just cramming, but knows how to adapt what he has solved in the past to the present scenario. Now, please note this. During your essay, you should keep referring to the words used in the question. During your essay, when you have essay question and you are answering essay question, ensure that you keep mentioning some of the words used in the question when you're answering your essay. But if this seems to become repetitive, then the best way out of it is to use synonyms for those words. For your senior in foreign level, I took them some aspect of the legal research, and I told them to be familiar with what we call transitional words. So those words will help you to connect your thoughts conversely. However, if you want to negate your earlier principle that you have discussed, use the word conversely. However, so that if you want to list advantages of something, you have mentioned one, then two, you now say however. So that means there's no flow, there's no synergy in what in the examples that you are giving. So you can use synonyms to change some of the words used in question. But that's for essay question. You must ensure that you keep on mentioning some of the words used in setting the question. So this makes it clear to the examiner that you are keeping the question in mind as you work. So let's move on. Now, know that where you are asked to disagree between A and B, you have to discuss what A stands for and what B stands for, after which you draw out their distinction. Now, you can look at it again. Where you are asked to disagree between A and B, you have to discuss what A stands for and what B stands for, after which you draw the distinctions. So, in answering questions, you mention first those concepts. If they say discuss Adiola, discuss Taiwo, discuss that, or disagree between, so disagree between A and B. Now, before you disagree between A and B, give us what A stand for. Give us what B stand for. Then before you now draw your decisions. Where you're asked to list and discuss X, Y, Z, you have to list before discussing. This is because there will be some marks allocated for listing your for listing those points before you discuss them. 2 marks, 1 mark can help you move from 68 to 70, or move from 69 to 70. So you can see reason why some people get 67, why some people get 70 on dots. So now, again, before I go to polling question, I just want to say this, that you also need to plan your answer. Okay. Now, under pressure of time, there is tempting to start, or it is tempting to start writing immediately. But I would advise that 5 minutes spent planning each essay question is well worth spending. Because it may mean that you write less overall, but the quality of your answer will almost certainly be better. When you are giving questions, don't just start writing. Okay? It will not make your work to be lit and neat. You see that when you start writing, you'll be crossing a lot of things. You'll be crossing you'll be crossing a lot of things. Then you start all the way again. So when you see a script that a whole page is cancelled, a paragraph is cancelled, it's because the person did not put up his thoughts before start writing. So under pressure of time, it's tempting to start writing immediately because you know, oh, time is good, time is going. But 5 minutes spent planning each essay question is well worth spending. Because if I were you, you start, oh, this is what this question is talking about. Then introduction, just do it by the side, maybe at the back of your question of your booklet. Just do the structure of your work. Plan your answer very well. Now, the plan need not be elaborate anyway. All you need to do is to just jot down everything you feel is relevant to the answer, including case names, and then organize the material into a logical order appropriate to the question asked. Just like I give you in your assignment, I said follow certain logical order. Okay, so to put it in order rather than wasting time copying it all out again, just jot them somewhere. So that's very important. It will show clarity of your thoughts. Now, after that, I also say that you provide analysis and facts. Very few essay questions require merely factual descriptions of what the law is. You will almost be required to analyze the factual contents. That is what essay question does for you. In some way, usually highlighting any problems or gaps in the law and suggesting possible reforms. That's what essay question does for you. Unlike polling question, essay question wants you to give the factual descriptions of what the law is. Then you almost always be required to analyze the factual content in some way, usually highlighting any problems or gaps in the law and suggesting possible reforms. That's what essay question does for you. So if a question asks you to analyze whether individuals are adequately protected by law or defamation, for example, you should not write everything you know about defamation, just like what I said about false imprisonment, and finish with one sentence saying individuals are or are not adequately protected. That would be a bad conclusion. Okay, so instead, you should select your relevant material and your all answers should be targeted at answering whether the protection is adequate or not. So if protection under law of defamation is adequate, you explain to us that, oh, in view of the provision of so section this, section that, it appears or it can be said that the provision of law of defamation is adequate to take care of incidences of defamation. If it's not, then you are telling us a gap that in view of the situation at hand, the law of defamation as it's presently constituted is not enough to it's not adequate to protect the claimants. So that is talking about the gaps in the law. So that is what essay question wants you to do. Now, if a question uses the word critically, as in critically describe or critically evaluate, the examiners are merely drawing your attention to the fact that your approach should be analytical and not merely descriptive by describing something. Derivation is this and that you are describing. You should analyze. Analytical discussion means that you do a bit of critique of that particular law or of that particular issue. So having said that, even if you do not agree with particular criticism which you have read, you should still discuss them and say why you do not think they are valid. So you could have read some materials like Ebenezer pointed out during the distinctions between exclusion clause and all that. It was talking about the Asdan's case and was saying that if that case has been decided under the 1984 Act, then the court should have reached different decision. That's a valid argument. So you are trying to let us know that the way that case ended, the way the court came with a conclusion in that case was wrong because of the fact that they started on the wrong premise. So then when you are done with this, try and get a good conclusion. Don't copy the question from beginning and make it and just paraphrase it and say that's your conclusion. So therefore, Lord Coke CJ was right to say every restraint of the liberty of a free man is an imprisonment, although it may not be within the wall of any common prison. That is not a good conclusion. Your conclusion should be a summary of your analysis. That should be what your conclusion stand for. Okay. So and I've already talked about the structure of your work. Okay, so it's always good to have good structure of your work. So hello class, can you still hear me?
Yes, sir.
Okay.
Sir, we can hear you.
Yes, sir.
Okay. A call came in and the call was distracting me. So let me move on. So away from essay question. Now I want to ask from the little explanation I'll give you about essay question. Do you seem to understand what essay question is all about? At least it's more straightforward than the polling question. But also for me, it's easier to pass polling question well than essay question, because in essay question you may need to convince the examiners that you know what you are doing. So when you're able to analyze the factual situations in essay question and you're able to conclude well, then of course you are sure of getting a good mark. But it's easier to get, for example, 18 or 20 in polling question than get to get in a 18 or 20 in essay question. Essay question is based on the opinion of examiner. So if you get this right, you can get a good mark. But if you don't cover all the necessary points the examiner is looking for, you may not get it 10 over 20. So I always advise students to go for polling questions. If you have like 3 polling questions in the exam, that's for me. I always treat towards answering polling question for reason that you will get to know very soon. Now, that's all about essay question. So we'll not waste our time on that. Now, for polling question, it has been argued that the introduction of polling questions into examination has done a good deal to redress the imbalance between intelligence and memory, but it has not get rid of memory work altogether. So, unlike essay question that you have to maybe master many cases that you use to explain all the factual situations that you have in the essay question. For polling question, you don't need to master many, but why it's also good to master many cases before the exam is that you may be lucky that a question can be lifted from a life case, a case that has been judged before. You'll be lucky that they just lift the facts and make it scenario. If you're able to mention the case in which that fact was lifted and taught to scenario, you are close to getting 50% already. So, however, this is usually where most students encounter problems. And here, I say ironically, it is simple to pass them down essay question since you can score after 0 in an essay question. And that's the truth. You can score after 0 in essay question. But in polling question, you will still get 1 or 2 marks because if you're able to identify the issues correctly, okay, and you're unable to discuss the applicable laws for those issues very well, but you are still able to give some ideas, you can still get your 10 over 20. Unlike essay question, if you miss essay question from beginning, that is the end. You can score 0, but not polling question. You only score 0 in polling question if you don't even connect your issues at all with the law. With the law, because again, it has to do with someone that has read widely. You must have read very well before you can say you know what the issues are. So here, I say that a polling question is a type of question whereby you are given a scenario or a hypothetical sequence of events, and you're asked to determine the law or laws applicable, or you're asked to advise the parties involved. Now, you may be asked to ask the parties involved. In the case, you have to know the fact in issue, the applicable principle or principles, you apply the applicable principle to the fact in issue, and you draw your conclusion. And I'm glad Papa has taught you how to identify issues. You identify issues from the situations, from the facts given to you, you identify the issues. If the question is on negligence, you don't just tell us by saying the question at hand borders on negligence, and you're discussing negligence. So issues are tied to facts. Issues are tied to facts. And I'll give it a good example here. I don't want to go into that because of time. So because this is already 11:02. I will leave the class in the next maybe 3 minutes so that I can join my outside class. But your class should look for a time for me. I don't want to take your normal time. Okay, I mean, as of today, I want to go and be reading your book so that you can maybe put your thoughts together for exam. But maybe weekend, if weekend is okay by you, I mean, I should be free on Sunday evening, so we can have a discussion on Sunday evening if you want. But if you don't want, then we can look for a day next week. A day next week, during our thoughts period. Okay. So because I have so much to say on polling question before I now talk on the general guide on how to read certain of cases and so on and so forth. So I will also send this particular scan copy to your class so that you can forward to your class. But note again that there are a lot of errors in this slide. So if I have time to work on it, it will benefit you in second semester. As you are seeing, I'll work on it and make it a proper notes so that you can also keep and as you are reading, you can also make reference to it going forward. It will help you. So Joy, before I go, is there anything you want to say?
Yes, sir. Sir, thank you, sir, for what you've explained to us. Sir, I also want to ask that you grant me leave to say this. So, sir, please, I want to plead that you tamper justice with mercy as regards the late submissions, sir.
No, Joy, that's beyond you. That is beyond me, it's beyond you. I've just told you about deadline. You need to, a serious student will work with the deadline. I was asked to get the papers from you on Friday. I extended till Monday. And for those that came on Monday again, I still gave it 30 minutes extra So for the exclusion clause and all that, I give 9 p.m. for a reason. And some people submitted 9:20. I pardon a few of them that indicated and defended in class. Others that did not indicate anything, they can't hold me hostage. Okay, just let's do that for now. Because my son are already calling me in housing law. Let's do that for now.
Sir, can I please say something, sir?
I'm done. No, I'm done. No, I'm done. No.
Sir, I submitted late, sir, because I
Okay.
wasn't. Sir, can you hear me, sir?
Class rep. So please get a date for me. They will continue.